Today we are going to understand collegium and judicial appointments in India. So first of all, what we would understand is what was the situation pre 1981. So pre 1981, the situation was according to Article 124, which stated that President under his warrant and seal after consultation, that appointment of judges would happen after consultation. Now this was a big question. What is this consultation? Is it concurrence or is it just his discretion? This was not clarified, and this caused a tussle in High Court appointments, and thus appeared the famous S.P. Gupta case. Under the S.P. Gupta case in 1981, post the emergency, the Supreme Court had a very interesting stance. It said that the consultation is not concurrence. Despite of the emergency misuse of this judge's appointment, the Supreme Court said that consultation is not concurrence. Then came the second judge's case, which is also known as SCARA versus Union of India. It is Supreme Court Advocate on Record, SCARA versus Union of India 1993, where consultation was equal to concurrence and it was binding in nature. This concurrence was binding to the president, that president would have to concur to the collegium. Now collegium here was first time invented, which consisted of CJI plus 2 senior most judges. Also note that the CJI itself of Supreme Court was to be appointed as the person who is the senior most judge in Supreme Court. This also was stated under the 1993 judgment. After that came the special reference number 1. This reference was made by the president in the third judge's case, also referred to. It expanded the collegium definition to CJI plus 4 senior most judges. Now these 4 senior most judges were for the appointment of Supreme Court, and also there was a provision that if any 2 judges would disagree, then the CJI should not send such recommendations to president. For High Court appointments, CJI plus 2 senior most judges were to be consulted, and along with the consultation or the advice of governor and Chief Justice of High Court was also taken. For the transfer of High Court judges, this is a very important nuance that you have to consider, that CJI plus 4 senior most judges are considered. Also consultation of Chief Justice of both the High Courts. Now why both here? The one from where it is to be transferred and one where it is transferring. Like for example, if someone has to go from Bombay High Court to Madras High Court, so Chief Justice of Bombay High Court, Chief Justice of Madras High Court, both have to be consulted. Now after all these judgments, there was clear establishment of collegium, and Government of India formed its Memorandum of Procedure for the first time accordingly in 1999. Now this Memorandum of Procedure was also administered by Ministry of Law and Justice. Now in 2015, a relook took place because 5 judges bench struck down by 4-1 majority that NJAC, National Judicial Appointment Commission, was invalid because the issue here was that the members consisted of CJI, 2 senior most members, 2 independent jurists and law minister. Now the Supreme Court or the judicial rationale for this striking was that political interference might occur. So that's why NJAC was scrapped. The 99th constitutional amendment was scrapped by Supreme Court under the SCARA versus Union of India 2015 case. Now what next? Next happened was redevelopment of Memorandum of Procedure according to whatever the judgments were given. So in December 2015, Supreme Court agreed that the government may finalize Memorandum of Procedure with unanimous view of Collegium. Again, Collegium was given supremacy. Now there is a procedure that occurred. The revised MOP on 22 March 2016 of government was passed on to Collegium, and the Collegium passed a draft, and like you can clearly see that Supreme Court, Collegium and government are tussling here. And the final view of the Collegium on 13 March 2017 was that rejection of a clause that government should have no power to reject, or no power to reject the appointment of High Court judge as a reason of national security. Now, this reason of national security was termed as vague by Supreme Court in recent times, and thus a new status report of 7 December 2013 was generated, in which Justice C.S. Karan case was discussed. Now, what is this Justice C.S. Karan case? It is a 2017 case of a 7-judge bench where the Supreme Court itself stated that Collegium system has failed to filter suitable candidates. Now, this is where the Supreme Court changed its prior stance. Supreme Court explicitly admitted here. And in 2023, this stance was nullified by saying that the judgment itself was a misjudgment and should have all stakeholders. Now, you can clearly see the vagueness that was earlier provided by government here is provided by Supreme Court or judiciary. All stakeholders. Now, this is also an issue, and this was later said. Now, there is another level of where the Supreme Court itself or the judges in the Supreme Court itself contradict their opinions, that I would like to share with you, that there are two views of Collegium of a same CJI just after changing the context. Like, one of his view was during his tenure, that at this time he was CJI, but now he retired, so he changed his stance. So during the tenure, he said that the Collegium system is the law of the land and should be followed to the T. It's such a strong statement. And after the retirement, he said that the biggest drawback, the law of the land now has a drawback, Collegium, is that the government sits on its recommendation for too long, to a very ephemeral term of judge, which leads to a very ephemeral term of a judge, suggesting that something new is required, in which all stakeholders should be considered. Now, this is a pro NJAC, I would consider it to be, and this is a very strong anti NJAC stance. Now, why such a contradiction occurs? Like, I would like to not call it a contradiction, but a time-based hypocrisy, where you can clearly see. Now, why this is occurring? Because of power. I would consider India to be a power-hungry society, where when you have a lot of power in you, you don't want to share it with other stakeholders, and when you don't have power, you just want to dilute it or have a pro-government stance for maybe anything. I would not like to comment on that, but I don't know. I won't say anything. So the power is the main concern here, according to my analysis. Now, that is all that I would like to say. I hope there is a clarity of what has happened and maybe why also. This, I would say, is a controversial opinion or a controversial fact analysis at last that I've done, which might not be of lot of use of lot of you. So that is it. So thank you.